Welcome to On the Issues with Michele Goodwin at Ms. Magazine. As you know, we report, rebel, and we tell it just like it is. And that includes with reviewing the United States Supreme Court's most recent term. I hope you'll sit back and take a very close listen as I'm joined live with Erwin Chemerinsky, Dean of Berkeley Law, Mark Joseph Stern, senior writer at Slate, Jamelle Bouie, columnist at the New York Times, Moira Donegan, a columnist at The Guardian, Sherrilyn Ifill, professor of law at Howard Law School and former CEO and president of the Legal Defense Fund, and Chris Geidner, legal editor at Law Dork. You'll also be hearing from H. Adam Harris as he gets us started before this live audience we recorded in Washington, D.C. at Georgetown University. Our friends, our listeners, sit back and take a very close listen.
In the morning, when I rise, in the morning, when I rise, oh, in the morning, when I rise, let America be the dream the dreamers dreamed. Let it be the great, strong land of love, where never kings connive, nor tyrants scheme. That any man be crushed by one above. Oh, let my land be a land where liberty is crowned with no false patriotic wreath. But opportunity is real. And life is free. Equality is in the air we breathe. Oh, let America be America again. The land that never has been yet and yet must be. The land where every man is free. To that land that's mine, whose sweat and blood, whose faith and pain, whose hand at the foundry, whose plow in the rain must bring back our mighty dream again. Oh, yes, let me say it plain. America never was America to me, and yet I swear this oath, America will be out of the rack and ruin of our gangster death, the rape and rot of graft and stealth and lies. We, the people, we, the people, we, the people must redeem the land, the mines, the plants, the rivers, the mountains, and the endless plain. All this great stretch of these great green states and make America again. Oh, let us make America again. Good morning, good morning. My name is H. Adam Harris, and I'm your MC. I am so honored to be here, and I thought I'd start us off with a little bit of that excerpt from Langston Hughes's "Oh, Let America Be America Again." On behalf of Georgetown Law and the O'Neill Institute, I offer sincere gratitude and admiration to each of you for joining us this morning for this year's Supreme Court term in review. The Supreme Court heard 60 cases this term, a period defined by critical tests of executive authority, structural administrative power, and civil rights. Today, we gather to hear from leading luminaries of the legal profession on the impact of this term and how we might navigate the truth of now as we seek the potential of the future. Friends, if you'll take your seat, we're going to welcome Professor Goodwin and our panelists for the Supreme Court term in review. Please take your seats, and we'll ask our panelists to join us on stage. All right. Thank you all. Professor Goodwin.
Can we give another round of applause to our rule of law panel and our panelists? How brilliant they are. So grateful. We are truly grateful to have been able to assemble a panel like you just heard with that level of depth, experience, and leadership on the rule of law, democracy, and on the ground. You know, one of the things that didn't come up in that last panel is that as we think about January 6th, and as congressional committees, law enforcement were trying to figure out who were the people that stormed the Capitol and that harmed our democracy, it was actually Liz Winstead and her group that were able to give over 2 or 3 dozen names of individuals because they spotted them because of the ways in which they had been harassing, bullying, and harming women outside of medical clinics. And they were able to say, oh, we know that person, and here's the information. And we know that person, and here's the information, which led to prosecutions and convictions. Liz, thank you so much. That's work of democracy. All right, so we're going to get started with this rough and tumble group. Thank you so much for being back together again. You might hear them interrupting each other, and that's completely okay. That's fair, absolute fair game. And the way in which we're going to get this started is Erwin, Dean of Berkeley Law. I'm going to ask you to just give us a quick overview of this term.
Sure. Thank you so much for having me. It's an honor and pleasure to be here. Like so many of us, I think I'm here because I do anything Michelle asks. If I was to characterize the term overall, I would say that it shows that it's a very conservative Supreme Court, and in cases involving President Trump, usually will rule in his favor, but sometimes against him. Michelle always asked me to start with some statistics about the term. The Supreme Court decided 61 cases with signed opinions after briefing oral argument. It's almost the same as the 58 a year ago. But keep in mind, in the 1980s, the court was deciding over 160 cases a term. In William Rehnquist's last term as chief, October term 2004, the court decided 85 cases. At the same time, the number of cases on the emergency docket, the so-called shadow docket, have tripled in the last few years. About 29% of the cases were 6-3 decisions. About 23% were 6-3, with the dissent being Justice Kagan in Jackson. That's about double the number of 6-3 decisions from a year ago. Once more, the justice most often in the majority was John Roberts, 95% of the time. If I was to identify a theme for the term, I would say that it was about the court and democracy. Let me give 3 quick examples of that. The first is voting rights. If you ask me what was the single most important decision of the term, I would say without hesitation, Louisiana versus Calais. I regard the Voting Rights Act of 1965 as the most important laws adopted in my lifetime. In 1964 in Mississippi, only 7% of eligible Black individuals were registered to vote. In Alabama, it was only 17%. In the states across the Confederacy, only 43% of eligible Black individuals were registered to vote. The Voting Rights Act of 1965 was intended to and made a huge difference. But in 2013, in Shelby County versus Holder, the Supreme Court struck down the provisions that required that states with a history of race discrimination get pre-clearance. Chief Justice Roberts, writing for the court, said, but there's still Section 2 of the Voting Rights Act that says that states can't have election systems that have discriminatory impact against voters of color. In Louisiana versus Calais, the Supreme Court effectively gutted that provision. The court said proof of discriminatory impact is not enough. There has to be proof of discriminatory intent, and it's very difficult to show discriminatory intent. Rarely will legislators express a racist motive. The court went further and said, if the legislature is acting to give a partisan advantage to a political party, then that's an acceptable non-racist purpose. So immediately, Southern states began redrawing election districts, saying we're doing so to give an advantage to Republicans. We saw Louisiana cancel its scheduled congressional elections to redraw them. Tennessee redrew its districts. The bottom line is this is going to mean the largest loss of Black representatives in Congress and state legislatures since the end of Reconstruction. And it was briefly suggested in the prior panel, the Supreme Court's opinion suggests that it might find all disparate impact liability unconstitutional, which would gut Title VII on employment discrimination, the 1968 Fair Housing Law, and many state laws. Second, there are the cases involving President Trump. My count, since January 20th, 2025, there have been 31 Supreme Court rulings involving challenges of the Trump administration, most on the shadow docket, some merits cases. This in itself is unprecedented. Never has the Supreme Court heard so many challenges to an administration for so long period of time. In 26 of 31, the Supreme Court has ruled in favor of the Trump administration. We saw key examples of that this term. On Monday in Trump versus Slaughter, the Supreme Court overruled a 90-year-old precedent and said that Congress cannot limit the ability of the president to remove the heads of federal agencies. This is an enormously important separation of powers decision, shifting power from Congress to the president. Last Thursday, there were a couple of immigration decisions. There was Mullen versus Doe, that President Trump could unilaterally revoke temporary protection status for 300,000 individuals from Haiti and Syria. There's Trump versus Lotto, where the Supreme Court held that the president has the ability to bar people from coming to this country to seek amnesty, notwithstanding a federal statute and international law. But at the same time, we can't ignore that in the tariffs case, Learning Resources versus Trump, the Supreme Court 6-3 struck down President Trump's tariffs. And just yesterday in Trump versus Barbara, the Supreme Court said that President Trump's executive order on birthright citizenship was unconstitutional. To me, the surprise of that case is it wasn't 9-0. Given the United States history, given the text of the 14th Amendment, given the precedent from 1898, given tradition, it should have been unanimous. On the other hand, keep in mind here that Justices Thomas and Alito have not once voted against the Trump administration in any of the cases. Third and finally, there's the issue of the relationship of the judiciary to democracy. When I teach constitutional law each spring, I always say to my students, the central underlying question of constitutional law is when should the judiciary defer to the democratic process and when overrule it? The theme here, and I know it sounds cynical, is that when the Supreme Court agrees with the democratic process, it professes deference, and when it disagrees with the result, it just overrules it. Compare two cases. Yesterday's decision with regard to state laws prohibiting transgender girls and women from participating in girls and women's sport. This was the case of West Virginia versus PBJ. The Supreme Court deferred to the legislatures of West Virginia and Idaho and their laws. The argument they gave was it was necessary for states to do this in order to preserve competitive balance and for safety reasons. But as Justice Sotomayor pointed out, there was no evidence in the record whatsoever to support this. There should have to be proof of this. The case should have gone back to require states to demonstrate it. It was all about deference to the legislature. But now compare this to Childs versus Salazar, case earlier this term. It involved Colorado law prohibiting conversion therapy for gay, lesbian, and transgender youth. The Colorado legislature found, with extensive fact-finding, that such so-called therapy is ineffective and harmful. There was no deference whatsoever to the Colorado legislature. It was about strict scrutiny. I guess if I had to give an overall assessment of the term, is that it was awful, but it could have been worse. And you know when you're saying it could have been worse, you're having a really bad day.
Give it up for Erwin Chemerinsky. Thank you, Erwin. All right, Sherrilyn, you led the LDF for a number of years, an organization key to furthering civil rights in the United States, taking on cases that brought us closer towards that arc of justice, closer towards living up the promise of the Reconstruction, the first, added to by the second, one of the laws Erwin referenced, right? 1965 Voting Rights Act. There's a 1964 Civil Rights Act, and out of that came so many protections and so forth. I want to start by asking how you have viewed this term, and then I'm going to turn to you to start us off with talking about Calais. And your microphone, friend.
First of all, thank you. Thank you all for being here, and thank you for assembling us, Michelle, and thank you, Dean Chemerinsky, for that assessment. Awful, but could be worse. Okay. I am as dismayed as I have ever been by this term for a variety of reasons. And I went to the court yesterday and earlier in the week, in part because I just thought, if this court is going to do what many of us fear it will do in the birthright citizenship case, for example, I mean, I think most of us recognize from the oral argument that it would not be unanimous. And so we already knew that, to me, that's a catastrophe. I just thought, they do so much of their work without ever having to confront anyone. And, I was shocked on Monday, there were 3 of us sitting in the section for members of the Supreme Court bar. It was me and Kristen Clark, former Assistant Attorney General for Civil Rights.
Who's brilliant.
And one other person. And, I understand why people don't come. Obviously, decision day should be on audio. Everyone should be able to listen to it. Certainly true. But I do think, and I will encourage in the future, it's really important that at the very least, I know they don't care about the people in the back, the public who comes in to watch. But I do think those of us who are members
this to be true.
Listen, those of us who are members of the Supreme Court bar, they should have to confront us when they do things like on one decision day, overturn 2 precedents, as they just did, right? When you're overturning Humphrey's executor in Colorado too, you should have to look at people who you have told about the importance of stare decisis, who have to actually make decisions about when to litigate, where to litigate, what we think our chances are before we invest money and time into litigation. And one of the key markers that we use to make that evaluation is stare decisis. We need to know what we think the law is before we challenge a violation of that law. So I went to sit there just to confront that moment. And the reason is because I think so many things went wrong with this term that we've reached the point of peak illegitimacy. I'm going to hold off Calais to the end of my remarks because we're all going to talk about Calais. But I think there's
you're going to talk about Calais, and I'm going to ask Jamelle about Calais.
Yeah, for sure. There are a number of things that I think are deeply problematic. One of them is, we are in the midst of an absolute power grab by this court. An absolute power grab. Not as though the Supreme Court didn't have a lot of power already. It is the 800-pound gorilla, in part because so many of us were ruined, shall we say, by having had our formative years in the 30 years when the court was doing things to expand democracy, as Guy Perryman was talking about. If your kind of fundamental formational idea of the Supreme Court growing up in this country was the court of Brown, right? Then you have a distorted view of the court. And so the court has been able to accumulate a lot of power in part because so many of us have believed that the court was a place where this could happen. So they already had power. Then they wanted more power, right? Some of that power they want for the president, and certainly these are people who believe in the unitary executive, but the power to decide what powers go to the president, they want that power, right? So they can create new doctrines like the major questions doctrine to just say, that seems too important for you to have that power, Joe Biden, right? And decide and arrogate to themselves that power. They can strip Congress of power. No, we will not, in the Shelby County versus Holder case, credit Congress with having pulled together a record that shows the need to continue Section 5 of the Voting Rights Act. And in fact, we don't even care that Congress overwhelmingly voted to reauthorize the Voting Rights Act because, as Justice Scalia said at the oral argument, we know why Congress did that. Who's going to vote against the Voting Rights Act? Even the name sounds great, right? So they won't even credit congressional votes as having any significance because they know why. So we just saw that Justice Jackson talked last week about this contempt of Congress, what she called academic contempt of Congress that many of these justices hold. But they absolutely don't believe that Congress is a co-equal branch of government. They just don't. And so they have taken power from Congress and arrogated it to themselves and sometimes to the president.
All right. So this is the way in which you've been seeing the court. And I think that you're probably not alone. Probably in this audience right here, there are a number of people who feel the same. I will say, and I want to turn to Calais, and we got a lot to cover in a brief period of time. I would like to take one pause for us to think about and to appreciate the federal judges, district court, courts of appeals, who have been taking on these cases and have been standing up for democracy and the rule of law. And many doing so under threat. Judges who can no longer walk the streets, have to drive to wherever they go, fear opening their doors, all of this. It's important to recognize the work that they've been doing. So over the last year and a half, there have been over 850 lawsuits that have been filed against this administration. And we're going to get to Calais right now. I'm going to ask you, I'm going to start with Jamelle and push you in on this question. But there's a lot of litigation, and that litigation, not all of it is making its way to the Supreme Court, as Erwin has mentioned, right? Because the court is taking fewer and fewer cases. A lot of it has been at the district court level and then making its way up. So of our various cases, let's talk about voting rights. 1965 Voting Rights Act, Pettus Bridge. People being bashed. It's when we begin to understand and see John Lewis as a young man, right? There are multiple people who are murdered. The point of it is just, let's register to vote. What Erwin said, and it went quickly, but it's real. He was talking about 7%, 17% of Black people being able to register to vote. For us to remember that in those southern places, if you were Black, you had to guess how many bubbles on a bar of soap in order to vote. Here's this jar of jelly beans. Guess how many jelly beans in this jar if I'm going to register you to vote? All of that. This is what gives you 7%, 17%, if you were lucky enough. Jamelle, tell us a bit about the Calais decision. What does that represent? What was it about?
Yeah, I think the Calais decision doesn't just represent a destruction of the Voting Rights Act. I mean, as Erwin said, if you are allowing legislatures to gerrymander on a partisan basis, knowing full well that in the South, there is no distinction between partisan and racial gerrymandering, which I'll say was the case in 1870 when the 15th Amendment was ratified. There has never in the history of the American South been a situation where you could distinguish between partisan and racial gerrymandering. So if you are allowing legislatures to do that, then you are effectively allowing the kind of extreme racial gerrymandering that we thought we got rid of with the Voting Rights Act, that the 15th Amendment was written to deal with. It is obliterating Black representation in the South.
What about the people who are confused by this, right? Because this was about drawing districts, right? And some folks would say, well, you're drawing special Black districts. Isn't there a problem with that? Why is there no problem with that?
I mean, so
is there a problem with that?
I don't think there's a problem with that. Even if they were, not a problem. But I think so I'm gonna rewind real quick. The part of the origins of this is that the original Voting Rights Act did not have an intent test. And in 1982, the Congress amended the Voting Rights Act to introduce a results and effects test, right? To say that, hey, if the voting changes result in a situation where Black Americans are losing representation, even if that wasn't necessarily the intent, you don't have to prove it. All you have to show is that that's the effect. And at the time, right, there was opposition to this. Notable opponents of this at the time, Chief Justice John Roberts is a young lawyer. And I think you should understand Calais as basically Roberts and Alito, who were at the time opponents of this, their ability to say, no, Congress is wrong.
So here's a question I want to ask you, Sherrilyn, to just help our law students who are in the audience, right? Because again, what is it with these districts? If Black folks have one district, can't they be satisfied? How does that happen? You got one. So what is it about the American South in terms of demographics that adds nuance to this?
Yeah, I mean, the reason that you can draw majority Black districts is because Black people have been segregated, not only in the South, but all over this country. You don't just walk up on the South side of some city and say, oh, all the Black people are
Chicago,
here.
Milwaukee, Detroit.
How is that possible? All the Black people in Harlem. Why is that? Because even Thurgood Marshall couldn't get an apartment in Stuyvesant Town when he
couldn't
took
get
over the
into the
legal
University
defense
of
fund.
Maryland.
So
Please.
I'm
Right.
giving you New
Girl.
York, though.
Okay,
I'm giving you
okay,
New York.
okay. Yes.
You see what I'm saying?
I
He
see
couldn't
what
get
you're
an-
saying. I
none
see
of
where
the-
you're going.
None of the Black LDF lawyers who get an apartment in Stuyvesant Town in Manhattan. And so they all had to live up in Esplanade Gardens in Harlem, right?
Yes.
So the reality of segregation in this country is that we are racially divided and we are as segregated as we have ever been. It may not be by law, but
And
it is,
sometimes it was. Paulie Murray.
I mean, today
Yes.
it is by custom, and we are inheritors of every time you redistrict. You know, like I did the 1991, which I'm convinced is the reason I left LDF as a young lawyer, because redistricting is so awful. And when you do redistricting, you start with the old map, right? You don't just say, oh, where are all the people, and start drawing new districts. Whatever was the map. So I started with the map that came from the 80s. And then you're making adjustments to that map. So we're just grandfathering that segregation is continuing. But here's the other piece. One of the factors that you have to prove as you're creating these districts is that you're keeping together communities of interest. And part of what this Supreme Court, what those conservatives want, is to suggest that Black people don't have a community of interest, that we're all just colorblind, and therefore we shouldn't care whose district that we're in. I want to just throw in a couple of figures because this is so important to build on what Erwin was saying. This is about power. Voting and districts is about power. The reason that Black people wanted power was not just to ceremonially, vote and to feel the dignity of voting. They thought that if they had power, they could change the material circumstances of their lives and their communities. So they wanted power. And they understood that the white people who opposed them, who didn't even want them to vote, were not going to make the material conditions of their lives differently. So they wanted to elect people with whom they felt an affinity so that they could make those changes. And so the key figures here are about that representation. When the Voting Rights Act was enacted, there were 70 Black elected officials across the whole country. Right after the 1982 amendments, 1,000. But again, 20 years later, 10,000 Black elected officials.
Yes.
This was the ability to develop Indigenous leadership that would give power.
And based on their population. So just so that you all know, we're talking about spaces where the population of Black people is a third of the state, 40% of the state, approaching 50%.
40% of Mississippi.
40%. And you got one person that you get to elect based on how the map is drawn.
That-
Mark,
Can I just add?
Yeah,
that I
let's
think that the
run it.
simplest answer to your very good question, why should we have legal protections requiring majority Black districts, is because look what happens when those protections are gone. We are seeing it right now after Calais, absolute annihilation.
yeah, in
of
fact, like what
political
happened right after
representation.
Calais, like Tennessee,
Tennessee,
Alabama.
all of these states racing to obliterate political representation for their Black communities, redrawing lines in obviously racist ways, which the Supreme Court now allows them to launder as mere partisan gerrymanders, even though, as Jamelle said, partisanship and race map onto each other perfectly. And you said, Michelle, oh, why shouldn't people be happy with, one majority Black district? Well, we don't even see one in Tennessee anymore. There are zero because all of the Black communities have been cracked, as we put it, and redistributed in majority white areas.
And what's the flip of that, right? Because folks will look and they'll be like, Black people, you got you got one. We never flipped that question. So what does that look like?
White people have them all. White people have total control of the congressional map in the state of Tennessee. They have near total control of the congressional map in Mississippi and Alabama, where there are huge Black populations. Like, this is a complete reversal of the Voting Rights Act and of the 15th Amendment. And it's being done in the name of protecting the 15th Amendment. That's the most perverse part of it
Which
all.
is a Reconstruction Amendment. I see you gripping, Chris. Yes, Chris Geidner, Mark from Slate.
It's not
Chris,
just the legislatures, because it was also then immediately after we have this whole discussion of the effects test, that they allowed redistricting to go into effect that had been struck down where they found intent, where a 3-judge panel had held a trial, had issued hundreds of pages of findings, and had found intent to discriminate by the legislature. And the Supreme Court then said, well, forget about that effects test decision that we just had in Calais. Now we're going to say that even intent isn't enough to stop the state from being able
Because
to go
all
forward.
of 13th Amendment abolishing slavery and involuntary servitude, right? No more of this forced rape and carrying people's babies so that they can be trafficked and sold. The 14th Amendment, which gives us birthright citizenship in its very first sentence, equal protection under law, substantive due process, those liberties, and 15th Amendment with voting rights. All right, that establishes things for students. Now, did you have one last piece?
One
Because-
last piece.
One last, because I want to actually turn to the anniversary of Dobbs to talk about that, and I'm looking at you, Moira.
So we just have to make clear about this colorblind constitution hokum, right? When the government wants to protect people of color by ensuring that they have equal representation, fair representation, this Supreme Court steps in and says, no, you can't do that because we have a colorblind constitution. But when the government wants to racially profile people who appear to be Latino or Hispanic and detain
Segue.
them because of their apparent ethnicity, suddenly and mysteriously, the
Suddenly and
colorblind constitution
mysteriously.
flies out the window.
Yeah.
So we just have to look at when this selective application of this principle comes in and when it mysteriously disappears. And that tells us a lot about the real goal.
Houdini. All right, Jamelle, then
I
we
just
got to
wanna
get
make
on to
one
Dobbs
very
and the
quick-
anniversary. You see this group?
one
You see
really
what I
quick-
have to do each year. Yes.
I think
Yes.
just before we move on, Sherrilyn made a great point earlier about this court taking power from Congress. And when we think about the Reconstruction Amendments, one thing that's so important to understand is that the Congresses that passed those amendments understood themselves to also have the power to determine what was the appropriate legislation that they could
Yes.
pass under them. And what's striking about Calais is Alito saying, no, we determine what is appropriate legislation under the 15th Amendment. We determine what it is under the 14th Amendment, this previous case. And that's so significant because I think that more than anything narrows the ability of Congress to offer remedies. If the only remedies you can offer are those that to rights that the court says exist and using in methods the court says is okay, then that in itself vastly neuters the ability of those amendments to actually do anything for anyone.
Thank you for that. And I think that there's so much attention yet to be given to those very courageous members of Congress and the Senate that gave us those Reconstruction Amendments. We do not do enough time in recognizing them and thinking about them because look, in 2026, we should be there. But imagine doing this, in 1865, saying that, no, we are going to reconstruct this Constitution. Those days are over. It's done. We're stamping it out. And that's what they did. All right, we're on the anniversary of Dobbs. So a few years ago, we were together. We were in California on Dobbs and talking about the Supreme Court overturning Roe v. Wade. Maura, if you can set the stage for what has been the case since then, the cases that we've had to think about, and what on the ground have people experienced?
Yeah, so, I would say in the 2 years or so following Dobbs, we really had sort of a flickering on and off of access to abortion in large swaths of the country. I think of it as like, when an old light bulb would be like almost done and you'd try to turn it on, it would kind of go on and off very quickly. That was what was happening as a lot of these state bans were litigated up through state courts. And now we have more or less here in 2026 reached our abortion rights stasis, such as you will, right? Like we know more or less what states allow abortion and more or less what states prohibit it. The sort of electoral and plebiscite options in a bunch of states have like more or less been exhausted, right? We know more or less what the map looks like. And Dobbs...
And the map actually looks very much like the Confederate map.
Yes, it does. Yeah. But much to Sam Alito's chagrin, Dobbs has not been able to prohibit access to abortion in these banned states because of the advent of telemedicine, mifepristone, and misoprostol provision, right? This is something that the Biden administration put into place on a temporary basis in 2021 and then on a permanent basis in 2023, I think exactly with an eye towards this, post-Dobbs reality in which abortion is inaccessible in large swaths of the country, where abortion medications, particularly mifepristone, the first in a 2-drug regimen is now accessible by mail, by telemedicine and by mail.
But at the same time, you have states like Texas and also Louisiana seeking to criminally punish doctors who are engaged in telemedicine with residents in those states.
Yeah, I want to draw attention to a case of a New York-based physician named Maggie Carpenter, who has warrants out for her arrest, I believe, from both Texas and Louisiana, and is not free at this point to physically leave the state of New York, where she is protected by a shield law that prohibits state authorities in the state of New York and in very similarly situated states. Most Democratic controlled states at this point have some version of a shield law that prohibits those state authorities from cooperating with the attempts to prosecute her in Louisiana and Texas. I think those shield laws, at least according to Sam Alito, who is piping mad about them, are likely to be object of further litigation.
And we saw that. So really quickly, just in thinking about this, because it's so important to level set in terms of factual information, Roe v. Wade was a 7-2 decision. 5 of those 7 justices were Republican appointed. Justice Blackmun, who wrote the opinion in Roe, was put on the Supreme Court by Richard Nixon. No one would say that he was a bleeding heart liberal. Just a couple years before the Dobbs decision, the Supreme Court had again reaffirmed Roe v. Wade. So this sort of like idea that Roe was some strange thing out in the universe, where the Supreme Court had over and over again affirmed it, including just a few years before the decision with Chief Justice John Roberts joining on with liberals to stamp out an anti-abortion law in Louisiana. Chris, did you want to say something about that?
Yeah,
really
I
quickly?
just, because you mentioned the New York Shield Law and how it's playing out in abortion, I just wanted to note in regards to the earlier panel, the discussion about sort of the intertwined nature of the attack on trans people and abortion, is that the New York Shield Law has come into effect with regards to trans rights because it's the only reason that we learned about the fact that the Department of Justice, which has been going after providers of gender affirming care for minors in blue states where it's legal, using administrative subpoenas over the past year, that we learned that they had turned to using a grand jury in the Northern District of Texas, where it would potentially be going to Judge Reed O'Connor, one of the furthest right judges on the district courts in the country. And the only reason we found out about it was because one of the grand jury subpoenas was given to NYU Langone, and they basically posted it and said, under New York Shield Law, we need to let our patients know. And I think they were conveniently helping us out by doing it, posting it, but it is this example of how these attacks are full-fledged, going at both trans people.
And it is interesting because Dobbs presented that like right after. One other thing I think that we should say, because even though folks are being able to get access to medication, abortion, that doesn't mean that there aren't women who are bleeding out in parking lots. That doesn't mean that there aren't women who have died. That doesn't mean that the state of Georgia had a woman tethered to life support who was brain dead so that the state of Georgia could have her body gestate a fetus. It doesn't mean that there haven't been women being helicoptered out of states to get reproductive health care because doctors are concerned about being criminally punished, losing their license to practice, or getting civil fines, or in Texas, where it can be 99 years incarceration if you're a doctor, $100,000 fine per lose your license to practice. So we have to remember those cases still exist, and that there have been doctors in Louisiana that have presented before their legislature saying, look, I've got an 8-year-old patient. Are you serious that this 8-year-old must carry her rapist fetus here, which could risk her life? And so those are some of the other of what's happening. But Chris, you got us thinking then about what's been taking place with regard to trans issues. And so I'm going to turn to you, and I'm going to turn to Erwin with thinking about, and you might jump in here too, Mark. But Erwin, if you could lay the sort of ground for how we understand Scrimeti and then Childs from this term, and then what the case that was just released with Hecox, what we should be thinking about.
To put this in context, this is a very anti-trans rights court. Let me put it in a little bit of
Please.
context. In the spring of 2025, the Supreme Court decided Trump v. Schilling. It involved whether President Trump could have an executive order barring transgender individuals from the military.
We wrote about that too, Erwin. We did. It was like Northwestern Law Review like 7 years ago. Like, what happens with, okay, anyway, yes.
The district court said that this would violate equal protection. Trans individuals serve with great distinction in the military. Court of Appeals upheld the preliminary injunction. The Supreme Court, 6-3, without any explanation, reverses it, allowing President Trump to bar transgender individuals in the military. In June of 2025, the case you just alluded to, United States versus Scrimetti, Tennessee adopted a law prohibiting gender-affirming care for transgender youth, one 26 states to do so. The consensus of medical opinion is that for transgender youth, those with gender dysphoria, such medical care can often be life-saving. The Supreme Court, 6-3, upholds the Tennessee law, professing the need for deference to the Tennessee legislature. November of 2025, Trump v. Orr, the State Department reversed earlier policy and said that an individual's passport had to list his sex, the sex as of identified at birth. In other words, it couldn't be gender identity. District Court says this is irrational. You want the passport to accurately reflect a person's gender identity when it's presented. The District Court said in some countries, having the passport indicate the sex at birth rather than gender identity could lead to harassment, violence, threats against individuals. The Supreme Court stays the preliminary injunction and allows the State Department to do this, saying it would irreparably harm the United States government to not be able to carry out its policy. And then yesterday, West Virginia versus PPJ. It involves laws in West Virginia and Idaho that essentially prohibit transgender girls and women from participating in girls and women's sports. The United States Court of Appeals for the Fourth Circuit, the United States Court of Appeals for the Ninth Circuit found that it violated equal protection as discrimination on the basis of gender identity. The Supreme Court yesterday, 6-3, said it doesn't violate equal protection. Michele, I put these cases together because you have to look at them cumulatively. It is a court that is very hostile to trans rights. Here I'd remind everybody that in 1938, the famous Caroline Products footnote 4, the Supreme Court said that the judiciary has a special role in protecting minorities that aren't going to be able to save for themselves from the political process. Trans individuals are exactly that kind of minority today, and yet the Supreme Court is entirely abandoning protection of them.
Thank you very much for that arc, Chris.
Yeah, I mean, I think that the passport case, I'm really glad you mentioned that. I think that that opinion was really one of the low watermarks, aside from Justice Thomas's concurrence yesterday, which was just horrifying in BPJ. But the entire rationale of the passport case and the dissent to it made clear, like, what you are doing is turning the concept of irreparable harm on its head. And I think that does connect completely with the Caroline products.
Can I give a
shout out
and then
on-
let's talk about
Can I give
Justice
a shout
Thomas
out
and that
on
concurrence.
equal
Right.
protection that brings these together? Because, this is why Justice Sotomayor's and very powerfully read dissent, at least partial dissent in the West Virginia case was so important, because she said, we should be sending this back for factual findings about whether, in fact, there is some safety issue with letting transgender girls participate in this particular sport. Like, what are the sports where there might be some danger? What are the sports in which there would be unfair competition? That's a factual question that we need. And the majority is running right past that because they know everything. But they're also doing it in the race cases, right? So this is why they don't care what Congress has accumulated in the record. This is why they don't care that the district court has found intentional discrimination. This is why they don't care about the tests that existed under Section 2 that required, quote, from the legislative history, a searching practical evaluation of the political, social, and cultural reality in that jurisdiction. That was the test. And that test includes having to establish that voting is racially polarized. Racially polarized voting means that majority of white people consistently vote
one way that is the opposite of how the majority of Black people in that jurisdiction vote. Think, if you will, of the last 3 presidential elections, right? That's racially polarized voting. And if you live in a community in which you are a minority and the white population is always hostile to your candidates of choice, then you will never have power. So that's one of the things you have to actually prove. And you have an expert witness. You have to get a political scientist. They have to run a regression analysis. We're not just doing this on a hunch or how we feel, but they don't care about facts. And that's why they're hostile to the district courts.
Yeah.
And I think I even said that last year, that's what the district courts represent.
So I see multiple hands here. So let's go to you, Moira, and then we're going to you, Mark, and then we'll go to you, Chris, and then we're going on. Yes.
Yeah, I am really glad that Sherrilyn, that you brought this up, because the underlying facts, particularly in the BPJ case, are like kind of shockingly innocuous. This is quite literally a teenage girl named Becky, who happens to be the only transgender student playing sports in the state of West Virginia, who has had no complaints and seems to get along well with her teammates, but her after-school activities are now the subject of Supreme Court intervention. And this is a child.
At that point, can you imagine that point? You're one individual in the entire state, and the Supreme Court has now decided to focus on you.
Not
for a
the
matter
only
of the
state where that
country.
has happened, by
Yes,
the way. This is an infinitesimally small
Yes.
number
Well, and
of children.
That is just very quick. I mean, that is sort of what was pointed out by Justice Sotomayor, is like the absurdity of this, because they allowed both the state to claim this severe concern about the attack of these trans women on women's sports as the reason why this law is needed, and yet also use the small number to say that this is too small.
Make it
of a
make sense.
subclass
Make it make sense.
to be an equal protection violation.
And Maura, back to Maura, and then Mark. Yes, Maura, where
Yeah,
did you?
and that's, there are factual questions about whether this child really does, in fact, have quote unquote biological advantage over her peers, because she was able to access the puberty blockers that the court allowed states to ban in Scrimity last year, right? This is somebody who has a genuinely unresolved factual claim about whether the state has an interest in preventing her from playing sports.
Which has not been resolved.
Is not the result.
We should not lose sight of the massive damage that these cases are doing to the law of sex discrimination more broadly, and to constitutional protections.
And to the individuals that are affected.
Yes, absolutely. It goes beyond just these particular plaintiffs. What the court keeps doing in this case is essentially saying that states can, by law, enforce sex stereotypes, that they can say boys should be boys and girls should be girls. I mean, the law in Scrimity in Tennessee specifically said we need to force minors to appreciate their sex. They shouldn't be acting like a different sex or transitioning to a different sex. They need to be this one sex that we think is right for them. And as Justice Jackson pointed out in her separate dissent yesterday, all of this runs headlong into this doctrine that the Supreme Court has had for many years against sex stereotyping by the government, that the government under the Equal Protection Clause cannot force us to live out its own ideas of what a man is and what a woman is. And these trans cases should have been easy on that basis, because in each and every one of them, the government is telling people, you think you're a man, but you're not. And so you don't get access to these drugs. You don't get access to this athletics program. You get access to the correct passport. And so, the previous panel talked about how women's rights are at stake here too. This is a prime example of it, because in ruling against these trans individuals, the court is absolutely diminishing constitutional protections for men and women, but especially for women who face discrimination because they are deemed insufficiently feminine.
And we are moving on. I saw those microphones being gripped over there. I'm not even going to look their way.
But this is so
Turn
important.
to
But it's
Erwin
so
while I'm
important.
looking away and asking Erwin.
So important.
Oh, okay, and then we got to get to tariffs. To tariffs, please. Okay, yes.
I just want to add to Mark's point to suggest that we're talking about a court that actually doesn't know anything about transgender experiences, boys, girls, medication. They don't know anything. Thurgood Marshall famously said, none of them knew anything about Black people before I got here. Not one of them. He said that.
Yeah.
And that was the truth.
It was
right?
the truth.
So the other piece to remember is this court has no humility. This is why they don't want factual findings, because factual findings allow a court, you have to be humble as a judge because you're being educated in that courtroom. And I say this as a civil rights lawyer because it's very rare that we are trying cases before judges who get what we're talking about. We have to make them get it, right? And so we have to present facts. And this court doesn't want to be bothered with that. They know that racism is
Right.
over. They
Right.
know that the South has changed.
Yeah.
They know that that these districts are not necessary
Yes.
for Black political power. They
Yeah.
know that women are not without their own power. All of the things they say are about a world they have created in their own heads, and they will not be disturbed from that world by the facts that lawyers are able to accumulate in court.
And the district court judges.
Chris, you were not supposed to do that. No, seriously. Erwin, now we need to hear about tariffs. Thank you very much. Yes.
I think that the terrorist case,
I know.
the terrorist case is enormously important because it does show that, at least in extreme instances, the Supreme Court is willing to stand up Donald Trump. What President Trump did, no prior president had ever attempted. Tried to unilaterally, without statutory authority, impose enormous tariffs. One thing to note about the case is that it was 9-0, that the president has no inherent authority to impose tariffs. Donald Trump had claimed that under Article 2 of the Constitution, he could do this. And all of the justices agreed that there has to be a statute that permits it. And the court ruled 6-3 that there's no statute that permits it here. The law that President Trump invoked was the International Emergency Economic Powers Act. It allows the president, quote, regulate importation. And Chief Justice Roberts, writing for a 6-person majority, said, regulate importation isn't tariffs. When Congress wants the president to have the ability to impose tariffs, Congress says tariffs. He said no prior president has claimed this authority. Again, the only surprise to me about this is it should have been 9-0. The statute doesn't provide authority. The Constitution doesn't provide authority, but Justice Thomas Alito and Kavanaugh dissented.
All right, Maura, I see you were you going to grab on tariffs?
I think I want to stress the importance of pairing the tariffs case
Okay.
with Cook from
Okay.
Monday.
Well, that's where I was turning to. All right, so let's actually go there, right? The removal matters. So start us off, please.
Yeah, well, in Slaughter, of course, the court found a novelly expansive removal power for the heads of independent agencies for the president. But in Cook, they carved out an exception for the Fed. And I
Make
think
it make sense.
this
Make
is
it make
what
s- make it
Amy
make
Coney
sense.
Barrett, to her credit, I think, asked in her dissent in Cook. And I think the underlying rule that seems to be emerging is that the president has very, very expansive, and perhaps this is too cynical even for this audience, but I don't think it is. The president's authority in the eyes of at least 6 justices seems to be limited only by, the risk to their own financial fortunes.
Which would be the Cook case. And Jamelle, I see you grabbing for the microphone. So how do we understand those two cases together? How do we make sense of both Slaughter and Cook? All right, we can fire here.
Yeah.
Here I can't fire. And what does it mean when a president can approach an agency and say, okay, just like fire these people?
I do think it's hard to make sense of Slaughter and Cook under any kind of logical consistency. If the presidential removal power is as expansive as Roberts describes in Slaughter, then it applies to the Federal Reserve, which isn't even, it's not as if the Federal Reserve is the oldest independent agency. It is not, right? Like looking historically, the Federal Reserve is modeled after previous agencies. And so if, for example, the removal power applies to the Interstate Commerce Commission, which is formed in the 1880s, it presumably also applies to the Federal Reserve. There's no historical reason why it wouldn't.
So for those who don't know, what are these cases about? They're like a couple of people who are removed. So what's the difference between the two? Right. So who's being removed in Cook and who's being removed in Slaughter?
Well, in Cook, it's a member of the Federal Reserve Board, not the
Yes.
president of the
Right.
Federal Reserve Board, Jerome Powell, but a member of the Federal Reserve. And Trump tried to I'm coming. Okay.
I love it. Like this call and response from our audience.
A
I
Black
love it.
woman
Yes, yes.
who sits on the
Yes.
Federal Reserve. And it was clear Trump wanted the Federal Reserve to do what he wanted it to do, to actually cover up for the freaking disaster he created with the tariffs, which would sometimes enormous one day, and then if someone said something nice about him, very small the next day. So they were also completely irrational. So he really had been pressuring Jerome Powell and the Federal Reserve to lower interest rates, I think is what he wanted. So he'd been gunning for the Federal Reserve, but there was real concern about whether he could go for Jerome Powell. So he attempted to trump up some reason why there was some malfeasance, why he would have cause to fire people on the Federal Reserve. He did it with Jerome Powell. He tried to say that there was a cost overrun on the new building that the Federal Reserve was constructing, which was completely crazy and made up. And if you've ever seen that
Just look
video
at the
of when he
reflecting
tried to
pool.
bum rush Jerome Powell with Tim Scott, it's hilarious. I keep it in my phone. And then with Lisa Cook, he got his buddy, who I think is about to be the DNI now,
Bill Pulte.
Bill Pulte, to say that she had committed mortgage fraud by describing a property that she held as her principal home as opposed to a vacation property. And it's clear that the evidence on that is really thin as a matter of fraud. But once that came out, once he had that announcement come out, then he tweeted that she needed to resign. And when she didn't resign, then he fired her. The other one was the FTC, was the Federal Trade Commission. And the reason why this one is so important, where he tried to remove members of the Federal Trade Commission, it's important because the Federal Trade Commission was the precise agency that was at issue in the precedent that held that the president could not remove these people, a case called Humphrey's Executor.
Right.
And so that decision, so I'm sitting there yesterday, and when I say overturning two precedents, like that usually doesn't happen in one like decision day, but that's what
But
they
that it
did.
did.
So that was the case.
And I'm turning to Erwin. I saw him grab
just wanna one
first.
thing.
Yes.
Trump v. Cook be much less of a victory than it may seem, or much
Yes.
less of a limit on presidential removal than it may seem. Because though the Supreme Court discusses why the Federal Reserve is different, the actual holding of the case was no more that under the statute, Lisa Cook was entitled to notice an opportunity to be heard before she was fired. The Trump administration had argued to the Supreme Court that once the president found there was cause, there could be no judicial review of that. This court was not going to say there can be no judicial review. And so what it said was she's entitled to have notice and a
Well,
hearing.
and that
Yeah.
she has a likelihood of prevailing on the merits, that they don't
Right.
have a lot. So it was to back him off of this, but you're right.
And Trump v. Slaughter is so important because Congress has created countless agencies, the Securities and Exchange Commission, the Federal Communication Commission, the National Labor Relations Board, and so many more, where it's provided some independence of the commissioners by saying they can be fired only for cause. And this is so Congress can carry out its powers. And the Supreme Court on Monday declared all of that unconstitutional. It embraced this idea of the unitary executive, which would seemingly mean the president can fire anyone in the executive branch. It would mean that even civil service protections that have existed since the late 19th century are unconstitutional.
And it
Yeah,
raises
and
some
it doesn't resolve as to tax court, court of claim, all of the non-Article 3 courts. And I think the sort of the big picture thing that I took from it is that actually John Roberts of the Cook opinion, listening to, if he was able to direct his opinion at John Roberts of the Slaughter opinion, he was actually making a case for Congress being able to pass removal protections. There was no way you can imagine a rewriting of the Cook opinion that actually is resolving all of these cases in favor of saying, like, there is a, even using their terms, so this isn't my choice, there is a history and tradition of allowing their Congress to pass these laws that have these restrictions. And yet it was just written as this one exception that has, as Mark said, there's no coherence to it.
Can I
yeah, really quickly,
can I
because then we're
add-
going to birthright citizenship.
and I think it's like so many of these cases turn back to a point that Sherrilyn made at the beginning about congressional power and the court. No Congress would have designed an agency where they could have effectively no influence or control over what happens to the commissioners. No legislator would have agreed to that. Part of the bargain of the agencies in their design is that Congress can shape what happens to the commissioners. And so it's described as the president has his removal power. I think it's more apt to say Congress cannot protect agency heads anymore.
Yeah.
By obliterating that ability of Congress to protect agency heads, it has turned these agencies into things that they weren't ever meant to be. They were not meant to be instruments of the president's will.
That's right.
And I think this represents a huge expansion of executive power and judicial power, because the court is also sort of saying any limits on the president that do exist, we're the ones who determine what they are.
You know, I'm glad that you mentioned that, because there is a weaponization that when you think about what our agencies do beyond finance, right? Making sure that our water, no abortions in them, but our water is clean and safe, the air that we breathe, that we have a Food and Drug Administration that does its work, the backdrop of needing people who are learned, who have capacity in those spaces, that are willing to push back against political pressures to do the right things and keep we the people safe. And it seems that that was one of the big threats that we see coming out of the Slaughter decision, and not much protection under Cook.
That decision really frightened me. I will say I am not easily shook, but it frightened me because this is about the safety of Americans. It isn't just about congressional power. That is certainly important, but the independence of these agencies are what is supposed to keep us safe. The Consumer Product Safety Commission, you know, you don't buy a toy for your kids until you've looked at what the age is and whether it has choking pieces on it. And like, there are things that keep us safe. And I looked at those boards that, you know, were mentioned in the dissent, you know, the Chemical Safety Board. So let's suppose a spill happens. They investigate, you know, chemical disasters. A spill happens. You need to add real information about the danger of that product to people who live close by and so forth. But you're telling me that if the manufacturer of that product is a buddy of Trump's, and the Chemical Safety Board
reflecting pools
is doing a study, and they want to interfere with the investigation, and Trump just says, well, I'm going to fire you. I'm going to put the people I want on it so that they'll come up with a conclusion that works for my buddy. Like, these are the ways in which we're kept safe. And so this isn't, your eyes can't glaze over at the Slaughter decision. It is very, very ominous.
So our last two, we're going to be wrapping up. Aren't they brilliant? Can we just give them all a round of applause? All right. So we're going to end on birthright, but before we get there, let's talk TPS. Right, Mark? Do you want to start? Yeah,
the bearer of terrible news.
Yeah.
So basically, here's what happened: Congress enacted temporary protected
and
status.
One of our justices does have family members who are from Haiti. All right, I'll just say that, but please go on.
I'm not getting into that one, Michelle.
I just said it, and then we'll just move on.
Congress enacted TPS to ensure that people who are coming here from countries where there is war and natural disasters and violence and all this stuff can remain here at least until it is safe to go home. And Congress did give the executive branch the authority to eventually terminate a TPS designation. But it said, look, before you do that, you have to go through all of these steps, right? You have to do this study on the conditions in the country. The Department of Homeland Security has to consult with these other agencies. There has to be 60 days at least notice so that people don't have their lawful status stripped away overnight, right? And then only at that point can the determination be made. And then Congress said, but that determination is not subject to judicial review. So at the end of the process, the decision made by the executive branch is final. So in these cases, the Trump administration terminated TPS for Haiti and Syria without following any of those steps, right? It completely violated the statute, just brazenly cut every corner, rescinded TPS in the most lawless, sloppy way you could imagine, didn't give proper notice, tried to strip this away from people overnight, didn't do the right consultations. And then when they got sued for it, went to court and said, oh, but the courts can't review any of this because the entire thing is insulated from judicial review. TPS beneficiaries sued and said, that's not true. The final decision may be insulated from judicial review, but there are very clear laws that require the government to go through the proper process, and they were violated here by a 6-3 vote in a horrific and cruel and callous opinion by Justice Samuel Alito. The Supreme Court ruled that, in fact, the entire process was insulated from judicial review and that there was nothing that the courts could do to push back against this egregious violation of this procedure. Justice Alito also rejected the constitutional challenge that the plaintiffs had raised to this termination. The plaintiffs pointed out that President Trump has said an inordinate number of super racist things about Haitians. He has said that they are eating cats and dogs, that they are poisoning the blood of the nation, that just outrageous racist stuff that should trigger equal protection scrutiny. And Justice Alito just swatted that away and said, even if we could consider that, he wouldn't agree that the court could even review that, but said, assuming that we can, this is not sufficient evidence of racism
Mark,
whatsoever.
if I could, so in the dissent were Justices Kagan, Sotomayor, and Jackson. And in part of Justice Kagan's dissent, she wrote, today the court undoes the preliminary relief, insisting that the terminations take effect now based on two mistakes about the plaintiff's likelihood of success. First, the majority asserts that the secretary's compliance with the TPS statute is in every respect unreviewable by the courts. But in fact, the statute allows judicial review of whether the secretary adhered to the procedures it mandates, which is what the plaintiffs dispute here. Second, and to the point that you were making, the majority claims to see no evidence that race played any role in the Haiti decision. But the evidence is there, Justice Kagan wrote, plain to see, she wrote, in the president's statements, which the majority, and for that matter, his own lawyers, cannot even bear to repeat. Once that much is established, the case for the interim relief is made. There is no dispute that the plaintiffs will suffer irreparable harm absent postponement of this TPS decision. So the plaintiffs are entitled to stay in this country while these suits go forward. Respectfully, I dissent.
So I want to bring you back to Justice Marshall. Not one of them knew anything about Black people before I got here, not one of them. This is the end of racism for this court. They have decided that anti-Black racism cannot be proved. Anti-white racism is flourishing, but anti-Black racism cannot be proved, right? It cannot, and if it is proved, there's no remedy for it, because to remedy it would make you racist. So essentially what they have done, right, is shut down the possibility of racial discrimination claims prevailing and being able to be remedied. If you could read that litany, and I was there at the oral argument, and I remember the justices, the three dissenters, asking Sauer, the Solicitor General, that the exact question with those things that Kagan pulls out, the poisoning the blood, they eat the cats and dogs, they're garbage, all the things, saying them, and Sauer kind of not answering, and the colleagues on the bench just kind of standing stark still. Like they knew that this was there, and they are saying there's nothing you can say. We will decide. Alito said it's not overtly racist, and that there are
this
neutral
is the
reasons
thing,
why
you know,
do
it's kind of like stuck on Bull Connor and white citizenry, right? Like if it doesn't look like, you know, dogs, fire hoses, bombs, then that is not
it does,
constitutional.
it does look like that in
Well, look at
the immigration
Minnesota.
context, and
Yeah,
in Los Angeles
yeah.
with you know.
And you know we got to go. I wish we did. Okay, Jamelle, you have
had something.
Yes, and then we get to birthright, and
to
we
connect
wrap
this
up.
a bit to the Alabama case. Alito saying that there might be these neutral explanations for this is the same. It's the same trick. It's the exact same trick. It's saying if there's any plausible non-racial explanation, not one that the people used, if you can imagine a plausible one, then that controls. And your job is, that controls, and therefore no remedy for it.
All right, so it's Chris and then Erwin, because Erwin, I saw you gripping your microphone too.
This is
yes.
one other example of the misuse of and degradation of congressional power, because, and this was very clear at oral arguments, the questions kept coming. Why would Congress say there are these 4 requirements in order to end TPS if there was nothing that could be done about it? And the court essentially doesn't answer that. They just say, well, that's just in the statute. And so it is
Congress just
like,
says stuff.
it is like
The other
with
Mullins decision.
removal, it just
Well,
ends the
just
power.
really quickly on the other Mullins case, right? If you could.
Sure. This is a case, Mullen versus Lotto, that involves whether or not the government can prohibit people who are in Mexico from coming to apply for amnesty. This is a statute that clearly would allow people to come for amnesty. Also, international law would allow people to come for amnesty. But the Supreme Court 6-3 said that the government can keep people, no matter what persecution they're suffering, from being able to do so. And this is the case where Justice Sotomayor wrote such a powerful dissent, going back to boats of people who were fleeing the Nazis, turned away, and then were perished in the Holocaust. Again, it's a case just about deferring to the president in power and immigration law.
All right, Erwin, why don't you start us off with birthright citizenship?
Sure. When the United States began in 1787, it followed English law that everyone born in the country was a United States citizen. This was the law until 1857, when the Supreme Court tragically decided Dred Scott versus Sanford and held that enslaved individuals were not citizens, even if born in the United States. When the 14th Amendment was ratified about a decade later, the first sentence of Section 1 unquestionably was to overrule Dred Scott versus Sanford. It says that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States in the state wherein they reside. In 1898, in United States versus Juan Camargue, the Supreme Court emphatically said everyone born in the United States is an American citizen. The court said the phrase subject to the jurisdiction thereof was just meant to mean if there was an invading army and a soldier had a baby, or the foreign diplomat had a baby, those children would not be citizens. This was the law. It was unquestioned as the law until January 20th, 2025. Back in the 1940s, Congress adopted a statute that used the same language of the 14th Amendment, clearly intending that all born in the country would be a United States citizen. President Trump's executive order, issued as Inauguration Day, essentially says only those born to citizens and those with green cards would be citizens. So those born to those in the United States on a visa or born to those who are undocumented would not be United States citizens. Every federal district court without exception, every court of appeals without exception, declared the Trump executive order is unconstitutional as violating the first sentence of the 14th Amendment. Yesterday, the Supreme Court 5-4 said that the Trump executive order is unconstitutional. Justice Kavanaugh said he would have found it violates the federal statute, though not the 14th Amendment. To me, the most chilling part of this was an opinion by Justice Alito in dissent. And I worry it's not going to get attention because the result was to strike down the Trump executive order. But what Justice Alito said is the president has the authority to redefine who's a citizen. And if the president wanted to do this retroactively, he could do so unless Congress would stop it. So to the Alito opinion, it would even be permissible for the president to say that United States citizens, been citizens their whole lives, but were born to parents who were here on visas or undocumented, could have their citizenship taken away. That's one of the most radical things that I've seen a Supreme Court justice say. But the bottom line is the Supreme Court came to the obvious correct conclusion. The first sentence of Section 1 of the 14th Amendment means everyone born in the United States is an American citizen.
I want to read from Justice Thomas's concurrence, or not concurrence, dissent, excuse me. Slip. In my view, he wrote, the citizenship order is not facially unconstitutional. Erwin, he didn't put Erwin in. The order is consistent with the original meaning of the citizenship clause, at least insofar as it applies to children born to parents here lawfully or unlawfully who are not domiciled in the United States. The citizenship clause was enacted for people who were born in this country and called it home. It was enacted for freed slaves such as Dred Scott,
who had a domicile here and therefore were entitled to sue as citizens. All right, I'll open it up. Who wants to say something about that? Okay, all right, let's start with you, Jamelle.
There's so much to say about this. Justice Jackson's concurrence, I think, does extremely able work of just dismissing this notion that the citizenship clause was narrowly written for the formerly enslaved. She shows quite clearly that both in the pre-war kind of intellectual developments that lead to the citizenship clause, and then also in the drafting itself, it was extremely clear that this was a broad remedy for everyone born in the United States. But I just want to make a quick factual point. Even by Thomas's standard, the citizenship clause, let me put this, in 1868, there were Black Americans who were not born in the United States. They were illegally imported into the United States as enslaved people. If Thomas is correct, then the citizenship clause did not make them citizens. And if you any understanding of the clause that does not make those people citizens is on its face incorrect. Like, it has to make them citizens.
All right, Moira.
Yeah, I wanted to echo something that Sherrilyn has been saying that really jumped out to me in this. One of several things that jumped out to me in this Thomas dissent is that, throughout this term and over the past couple of years, we've really seen an inversion of the Reconstruction amendments to basically be like photo negatives of their like historical intent, right? Suddenly, instead of being about like remedying the status of racial minorities and particularly Black people in the US, they become these guarantees of color blindness that in fact make such remedies unconstitutional, right? Not here. Here we get almost like woke Clarence Thomas about like focusing on the very specific historical condition of the formerly enslaved. And I just think that there's something about that reading that reveals the bad faith of this inversion of the Reconstruction amendments. They know it's a misreading.
Also such it is such an awful dismissal of what is one of the highest moments in the history of the country, one of the most important moments in the history of congressional legislation and decision making in our country. And what you mentioned, that we could be doing it now, but 1865 was 1865. That is that we'd had a war, that 600,000 people were dead, that the president who had held the Union together was assassinated by a Confederate conspiracy. There were skirmishes still happening this was a very, very difficult time. And the people who decided how to try and create a template that would allow this country to go forward, they actually did know something about race. Many of them were abolitionists, right? Mm-hmm. And they were drawing from a wide variety of sources. And I'm so glad that Justice Jackson cited many of those sources, the colored conventions and all kinds of writing, Frederick Douglass. It was beautiful to see that. And they were drawing on all of that because those people were shaping the ideas about citizenship and equality during that period. And what they created was something, by the way, that was designed absolutely to ensure that Black people would be citizens, and not just enslaved Black people, because if you read Dred Scott correctly, it said that Black people could not be citizens, mm-hmm. and whether enslaved or free. And so it was to ensure that Black people were citizens, but they had explicit conversations about the children of immigrants. Of course, they had their prejudices as well. And of course, there were legislators who said, but what about the Chinese laborers? Yes. They can't even be citizens here, but are we going to be overrun in California by the Chinese? Right. And you had the retort that Chinese laborer cannot become a citizen, but if they have a child born here, that child is a citizen. So this explicit point was discussed by that Congress.
And we saw it in precedent. Mark,
and yet this Supreme Court thinks that they've come up on something, or at least the conservative stalwarts think they've come up on something so new that they can just hand this power to the president. And the last thing I want to say,
because we're going to wrap up, I got to be
is that every one of the Reconstruction amendments includes a clause that says Congress shall have the power by appropriate legislation to enforce the guarantees of this provision. The president is not in the mix. Now we can talk about Kavanaugh's, what Kavanaugh thinks happens. But if there's one place where the president ain't in it, and I can assure you the president's not in it, because those founders had just faced the vetoing of the Civil Rights Act of 1866, which
Yes.
included birthright citizenship, from the
Exactly.
president, Andrew Johnson. And that's why they wanted to create a 14th Amendment. So we know this was a slam dunk. It should have been decided the first day. And that the court
And
waited a
9-0,
year and a half.
which raises a number of issues which we don't have time for, but how the court
my
could
assistant Lauren is handing out
very quickly decide
free
Calais,
constitutions.
but could not in time to dismantle voting rights, but could not decide quickly whether birthright citizenship is the law of the land. Mark, last word on that?
Well, it brings us straight to Brett Kavanaugh, unfortunately, because as Sherrilyn said, right, Kavanaugh has this dissent where he says, okay, fine, it's barred by statute currently, but he says Congress could change that statute, right? And he claims that the children of temporary immigrants today are relevantly similar to the children of diplomats and foreign ministers in 1868 who enjoyed immunity from U.S. law, which was precisely why they were excluded from the citizenship clause. It makes no sense, but he has this ode to deference to Congress. He says the courts need to defer to Congress's decisions here. Where was that, Brett Kavanaugh, with the Voting Rights Acts, with TPS, right? With independent agencies? No deference to Congress there. But when it comes to stripping birthright citizens of their American citizenship, Kavanaugh
Okay.
says let Congress do whatever.
All right, really quickly, because I promise there's food and refreshments outside, and we have to stop. It's like time. Really,
Yeah, it just sort of summing up what, and Erwin mentioned this, that you have this reality that we are seeing time and time again, that the lower courts and the appeals courts looking at the law, regardless of the president who appoints them, are unanimous. And we saw that not just in birthright citizenship, but we saw that in the removal cases. We saw that in the impoundment cases. And importantly, we saw that in the trans cases before this radical court decided to turn trans cases on their head.
all right, Jamelle, I saw you pleadingly, so like 30 seconds.
30 seconds. Mark made a reference to birthright citizens. I think it's very, very important to say, and this gets to the true radicalism of Alito's dissent, that how we determine citizenship in this country is by birth. Everyone is a birthright citizen. Unless you're naturalized, everyone is a birthright citizen. If you take away that guarantee, not a single person can definitively prove their citizenship.
So thank you. Please give it up for this amazing, amazing panel. And I want to just briefly read from Justice Jackson's concurrence. She wrote, I join the court's opinion in full. I write separately to respond to some of the themes in the principal dissent. Despite his longstanding endorsement of a, quote, colorblind constitution, Justice Thomas now surprisingly suggests that the citizenship clause was a race-conscious remedial measure relating only to, quote, freed slaves such as Dred Scott, and those shared with him certain characteristics. It is for this reason, he says, that, quote, children who were born in the United States but to parents not domiciled here are not entitled to claim birthright citizenship. But that narrow vision of the 14th Amendment bears little relationship to the history of its ratification. Even worse, Justice Thomas's telling elides the entire point of the second founding. The Reconstruction Amendments were an anti-caste, anti-subordination reset for the nation, not a mere spot treatment for the dark stain of slavery. All right, please give to our panelists, and also gratitude to our interpreters. Thank you so much.
This has been your host, Michele Goodwin, reporting, rebelling, and telling it just like it is on the Issues with Michele Goodwin and 15 Minutes of Feminism, our Ms. Magazine and Ms. Studios joint productions. I, Michele Goodwin, am the executive producer of Ms. Studios. Our producers for this episode are Roxy Zoll, Oliver Hogg, Allison Whalen, and our Ms. Studios intern, Emerson Penagrahi. The creative vision behind our work includes art and design by Brandy Phipps, editing by Natalie Hodlin and Emerson Panagrahi, and music by Chris J. Lee.